Hi, everybody. Welcome to Introduction to Asylum Law. This is Melissa and Lauren. We're with IPU. I just want to get some of our kind of technology pieces out of the way. Really quick, Chanel, if they're in listen only, do they have to put their questions and stuff into the chat, or can we just put people in a mode where they can ask questions if they want to?
I'm going to unmute all of them.
Okay.
And then they should be able to speak freely. So let me just double check. I'm going to unmute all of you. If you can just, one of you, even just unmute yourself so I can double check whether or not you are unmuted and unmute yourself freely. So give me 1 second. Okay, so you all should be able to unmute yourself. So if you can just unmute yourself and say your name, just so we can double check.
Yes. Hi, channel. It's Elvira.
Hi, Elvira.
Myself. Yes.
Awesome. Then everyone should have the ability to unmute themselves. So if you do have a question, I would just say wait until there's maybe a lull or something like that to ask it. You can also put it within the questions box as well, or in the chat box too.
Okay, and just to say, we want to keep everybody able to speak when they want to ask questions, but also, as you'll see, we have a number of examples that we'll have in the training, and that this training really works better if we can have a conversation. We have a small enough group of attendees that I think we can do it this way. So we really do encourage, if you have a question, please don't hesitate to ask. In particular, if we have an example that comes up where we're asking you to use some of the law that we're starting to introduce. Please don't hesitate to answer. Okay. All right. So welcome to today's training. It is Introduction to Asylum Law. Lauren, I'll let you introduce yourself. I'm the Associate Director of the Immigrant Protection Unit, and our unit obviously does quite a lot of asylum work in both a defensive and affirmative posture, and we'll talk a little bit more today about the differences between the two. Today's training is meant to be a real introduction to asylum law. We'll be covering only the basics and the practice in affirmative, non-defensive, non-deportation related proceedings. Lauren, do you want to introduce yourself before we get started?
Yep. Hi. Hi, I'm Lauren Rafe. I am a supervising attorney in IPU. And the team I supervise tends to work on a lot of asylum cases in the defensive posture, which is, something that, as Melissa said, we're not going to address with quite as much detail. But the law is the same everywhere. It's just about how you're presenting it and who you're presenting it to. So keep that in mind in case you have questions.
Okay, so today's agenda, we're going to be covering first our sources of law. Where does asylum law come from? Unlike many other types of immigration law or areas of immigration law, the sources of asylum law actually are based in international convention. We're also going to be talking about the actual domestic law and different aspects of asylum law and how they're applied, and also how they've been interpreted both over the years and more recently under this administration. We'll be talking about some of the proposed changes that have been announced that would greatly impact everything we're teaching you about basic asylum law and some of the protections offered to those seeking asylum in the United States. And then I'm going to touch very, very, very briefly on two forms of relief that are often associated with asylum, and one form in particular that tracks our obligations under the conventions that we're going to talk about today, which is withholding of removal, and we're going to talk about the Convention Against Torture. And then for the last part of our training today, we're going to be talking about how does one actually file an asylum application? What goes into it? What are the nuts and bolts of putting it together? What are the different pieces that you have to put together? And we're going to talk a little bit about how to start thinking about what types of evidence might exist and how to get it. And finally, we're going to talk very, very briefly about the asylum interview. keeping in mind that some of this process is up in the air because of what's happening right now during the pandemic and what we've started to see. Okay. Okay, so first we're going to talk about the legal framework for asylum law. Where does it come from, and what are the different elements of asylum? So generally speaking, the sources of law for asylum are numerous. The first being the 1951 Convention on the Rights of Refugees, and we're going to talk about that in a little bit more detail in the next slide. And that's really what forms the backbone of asylum and refugee laws in the United States. As we'll talk about, it sets forth the definition of the word refugee, and it outlines the rights of the displaced, as well as the United States obligations under that convention. Okay. We're then going to talk about the Immigration and Nationality Act, which is the domestic law that puts into action our obligations under the convention. Okay, because the 1951 convention is not self-executing, it doesn't create laws in and of itself. We had to promulgate the different statutes in order to start to offer the actual protections that we've promised to refugees and asylees. Okay, the backbone of immigration law in the INA is found generally in section 208 of the INA. Okay, we're then going to be talking a little bit about the regulations, which are promulgated by agencies, the Department of Homeland Security in this case, and those carry out the actual procedures by which we're actually offering all of the protections that we're promising in both the statute and the convention. And then finally, we have case law that interprets both the INA and the regulations, okay? Case law in terms of asylum law comes from a number of different places, the first of which are immigration court decisions. These are generally unpublished and not binding. The second source of law that we'll be talking about today is the Board of Immigration Appeals. This is the BIA. This is an administrative appeals body that is binding on all immigration courts in the country, okay? And finally, we're going to be talking about circuit courts today, which can interpret the BIA, but are binding only on the circuit in which it sits. Okay, okay, so first, we're going to talk a little bit about the 1951 Convention relating to the status of refugees. So in the convention, we have set forth the definition of refugee. Okay, you can see it here. The term refugee shall apply to any person who, owing to well-founded fear of being persecuted for reasons of race, religion, nationality, membership of a particular social group or political opinion, is outside the country of his nationality and is unable, or owing to such fear, is unwilling to avail himself of the protection of that country. Okay, so as we were touching on before, the convention actually forms the backbone of the asylum and refugee laws in the United States. But you can see that some people are actually not captured in this definition, right? It doesn't capture all people who are displaced. So if you're displaced internally, but you don't leave your country, you're not eligible for asylum or refugee status. It also doesn't capture people who are generally displaced because of general civil war or strife or environmental changes. It covers a very discrete group of people who are outside of their country, cannot return because of persecution on account of some protected grounds, okay? So we're gonna parse this more closely and how our domestic law has interpreted this convention in domestic law. Okay, so Article 33 refers to essentially the core principle of the 1951 Convention, which is essentially that of non-refoulement. And this asserts that an individual who meets the definition of a refugee can't be returned to a country where they face serious threats to their life or freedom. Okay, this is now considered a customary rule of international law. And as we'll talk about later, this tracks more closely our obligations under withholding of removal, okay? And the protections offered by asylum are slightly broader than this, because you can see under Article 33, we are simply obligated to not return somebody. We're not necessarily obligated to offer them the full rights of citizenship and protection that we do if you win asylum. And as we'll talk about later, for this really important reason, asylum has an element of discretion, whereas withholding of removal and Convention Against Torture do not. In other words, if you qualify for asylum based on the statutory test, you may still be denied it as a matter of discretion, whereas you cannot be if you are applying for withholding of removal. Okay, so now that we've briefly talked about the idea of the background law and the convention, I want to start talking about the domestic law. Okay, so the definition of a refugee or an asylee is set forth in Section 101A42A of the Immigration and Nationality Act. Okay, and you can see here it tracks very closely the definition that we just saw in the 1951 Convention. And Section 208B1 of the INA tells us that an individual can be granted asylum if they meet the definition of a refugee. So these are our domestic laws that have been promulgated in response to our international obligations under the convention. Okay, in turn, you can see here, drilling down even further, these are the sections of the CFR, of the regulations that correspond to the sections of the INA. Okay, so the regulations here actually tell us procedurally, well, what are the requirements for asylum? We now know the definition is set forth in Section 101 and Section 208 of the INA, but the regulations then set forth how one actually is going to be able to establish that. Okay, so you can see here, Section 208.13b and 1208.13b of the INA tells us that an applicant can qualify for a refugee or asylee here, either because he or she has suffered past persecution or they have a well-founded fear of future persecution. We're going to talk a little bit more about how those two ideas relate to each other. Okay, also keeping in mind that you can show both. Many of our clients show both. They have past persecution and they also have a well-founded fear of future persecution. However, as we were looking at and discussing during our discussion about the convention, it can't just be that you have any past persecution or that you have any fear of going home. You have to have a well-founded fear of returning home or have had past persecution on account of one of these 5 protected grounds, right? Race, religion, nationality, political opinion, and or membership in a particular social group. The and or is really important here because, as we'll discuss, many of our clients actually have experienced persecution or have a fear of being persecuted on account of one or more of these groups, and that we often assert as many as we can. Okay, I'm going to turn it over to Lauren to talk a little bit more about what we mean by persecution as we dive into the actual definition of this regulation. How do we actually prove this?
Yeah, so that's sort of always the first starting point of any asylum case is proving that your client has been persecuted or has a fear that they will be persecuted. So I'm going to start with past persecution. I'm going to start by talking about people who have already been persecuted because that's often what we see. Not always, but often what we see with our clients is that they have gone through some kind of, severe trauma, and that's what caused them to leave in the first place and come to the United States. There's not a definition in statute or regulation or in the international treaty, the 1951 Convention, of persecution. Currently, the way that we arrive at the concept of persecution and at proving whether our clients have experienced it or not is entirely through case law. So the sort of seminal case, one of the seminal cases on asylum, which was decided by the Board of Immigration Appeals, which is the first line appeals court for immigration cases within the agency before it gets into the actual federal courts, is matter of Acosta, in which the BIA defines persecution as a threat to the life or freedom of or the infliction of suffering or harm upon those who differ in a way regarded as offensive, and that, according to the board, encompasses a variety of forms of adverse treatment, including non-life-threatening violence and physical abuse, or non-physical forms of harm. So in other words, it's pretty broad. I mean, there's a lot of room for interpretation as to what constitutes persecution. It can be life-threatening harm, it can be serious harm that's not life-threatening, and it can even be harm that's not even physical at all. But it has to be more than just mere discrimination. It has to be something more intense than just mistreatment. So all of that's very vague, but vague is sometimes good when practicing law because it gives you room to say whether what your client experienced is in fact qualifying. The other thing to note about persecution is that, as with many forms of hardship or past traumatic experiences, it's to be viewed cumulatively. So if your client has suffered multiple, if the person applying for asylum has suffered multiple small acts of threatening or abuse that wouldn't individually rise to the level of persecution, the adjudicator is supposed to consider them as a whole and consider whether the pattern of acts all taken together rise to the level of persecution. Let's see. So things that do constitute persecution include serious physical harm. That's a pretty obvious one, right? If someone is beaten up pretty terribly, suffers major injuries, that would constitute persecution. In addition, coercive medical or psychological treatment could count. So if someone, for example, is forced to undergo an abortion or a sterilization, or if someone is forced to undergo years of conversion therapy, if they identify as gay, that would constitute persecution. Arrest or custodial interrogation could rise to the level of persecution if that arrest and detention or interrogation is disproportionate to the crime at hand and is also discriminatory in nature, which we'll talk about a little bit more later, that it has to actually be tied to the protected class. So for example, if someone is subjected to a traffic stop, they run a stoplight, and in response to running a stoplight, they get beaten up by the cops and arrested for many days without hearing, that would be persecution, even though the act that caused them to come in contact with the police was technically illegal. There are also some specific types of harm that have been articulated in gender-based cases. So, for example, rape is considered a per se form of persecution. In addition, female genital mutilation is considered a per se form of persecution. And another one is forced marriage, which is considered a form of persecution, although that one's a little bit less clear than the others because it's not so much that the forced marriage is the persecution, it's the things that might happen as a result of the forced marriage. It's presumed that if someone's being forced into a marriage, they're probably going to experience things like rape or beating because of the lack of consent that was, at the beginning of the relationship. Now, persecution under the law has to be inflicted by the government of the country that the person is fleeing, or by a person who the government is unable or unwilling to control. That's the legal standard right now. That leaves also a fair amount of leeway for us to discuss potential persecutors that are non-governmental in raising asylum claims, because unable and or unwilling to control means either that the government isn't trying to stop them, or that the government has such limited control over the country as a whole, or the particular people who are persecuting the asylum seeker, that it doesn't matter if they want to stop it, they just simply can't. So government actors, it's important to note, government doesn't include, it doesn't just mean like the central government. It can also include government employees, such as military officials or police officers. You can argue that those are governmental actors. Persons the government is unwilling or unable to control often includes guerrilla organizations, gangs, or members of the person's family, because oftentimes, so guerrilla organizations, the government's unable to control. If they could control a guerrilla organization, it would not exist because they are directly in opposition to the facts of the government. Gangs are sort of a similar situation. You can argue that the government is unwilling to control them because oftentimes government officials are acting in collusion with gangs, but even if they wanted to, it's clear from the way in which gangs are widespread in certain regions of the world that the government's just not able to stop them. Family members are a different sort of situation. Often that's an unwilling rather than an unable, because they're isolated actors. The family is only so big. It's not taking over the country, but oftentimes in many countries, including here sometimes, the authorities choose not to get themselves involved in what they believe to be family disputes. So that would be an unwilling situation. Okay. So the current standard in order to prove that the persecution was with the government, either consent or their inability to stop it at the very least, is from the case matter of AB, which was certified by the Attorney General to himself in 2018, so not too long ago. And the standard says that the applicant must show that the government condones the private actions or at least demonstrated a complete helplessness to protect the victims. So in other words, there has to be some evidence in the record that the government really can't or really won't. It's not presumed. So that's where we often find articles, news articles, reports from international watchdogs like Amnesty International or Human Rights Watch, that would tend to establish that even if the applicant didn't report to the police and seek help, it would have been fruitless to do so.
Right, and just to note that this interpretation of the unwilling or unable standard is a complete break with how this aspect of asylum law has been interpreted for many years. And so, and Lauren is totally right, we put into our evidence packets copious amounts of evidence showing why the government is unwilling or unable to support and hope that we meet this kind of very vague, complete helplessness standard. But this standard itself is questionably a large break from the interpretation that has always been of what standard it should be, and is arguably in dicta in AB.
Right. That is a really important point, that this is what we try to prove, but we also make the argument that this isn't actually necessary to prove. But nevertheless, it's usually important to try and put in as much evidence as you can to show that the government is in some way either not effective or else purposefully choosing not to care about this population or this issue. Yes, there have been many changes in asylum law, and there are many more to come over the past few years, which we'll talk about in a little bit more depth later in the presentation. That this is an area of law that is currently very much in flux after several decades of it being pretty steady. So, so we're all learning as we go along these days.
Okay, as promised, here's our first case example. Please unmute yourself. This is a much better training to do in person, but I think this should work over GoToMeeting.
So do you want me to read it aloud?
Sure.
So Mr. S is an ethnically Gilder man from Florin. When he lived in Florin, he was an activist for Gilder rights. Throughout his time living in Florin, Mr. S faced discrimination from ethnic Florians. One night, Mr. S was arrested at a rally by the police for lacking the proper permit. He was imprisoned for 2 months, and during those 2 months, the police beat and electrocuted Mr. S. After Mr. S was released, he was unable to obtain any work because of discrimination. After his release, he received threatening phone calls and texts. One night after his release, Mr. S was threatened and beaten by a group of ethnically Florin men. He didn't recognize any of the men and does not know if they were working for the government. 3 months after his release from prison, Mr. S used a false passport to leave Florin and come to the United States. He is now seeking asylum. So, first of all, do you think that Mr. S has experienced persecution? And if so, what was it?
Just unmute yourself to talk, or you can put it into the chat. Lauren, I can't see our chat since I'm sharing my screen. So if you see any questions pop up, maybe you can read them.
Yes. I do not see any yet.
So what kind of persecution can you identify here? You can just call out one. Let's not even talk about the persecutor yet. We're just talking about types of persecution.
If any. If your answer is none, we can talk about that too.
Mm-hmm.
Quiet group.
I promise you I will wait until we have an answer. Why don't we start with the arrest? Was the arrest persecution, and why?
No.
Okay, so we have a no. Anyone else have any other feelings about the arrest? Okay, that's actually a good distinction. Was the arrest and then the imprisonment for 2 months and the electrocution together persecution?
Yes.
Okay, why?
Well,
Because
the
I
arrest,
think that's go. Tell us.
arrest could really just be because he lacked a permit, but torture
Yes.
is persecution.
That's right. So maybe the arrest itself, if you had a client who said, well, I was arrested for lacking a permit, you'd say, well, you were arrested because it was arguably proper, right? But this is what Lauren was talking about earlier, that where the punishment far outweighs the crime here, lacking in a proper permit, we can get into the land of establishing persecution. What about the inability to obtain work and the discrimination? Is that persecution?
I would think you'd have to figure out how to establish why he didn't get work, or if the government somehow was responsible for his not getting work.
Mm-hmm. Mm-hmm. That's right. And so you'd want to know, why aren't you getting work? Or people just like, what happened when you were refused work, right? Let's say the government is in charge here of getting you work, and somehow he's just being denied work after job after job after job. Could we maybe argue that's a form of persecution?
And it looks like someone put in the questions, and I believe just let me know if this was in reference to the question of work or whether this was in reference to detention. But in the sense that he could not report it if it was state sanctioned. So I don't know. I think that could apply to both, and it would be a good answer in both cases. But if the state is the one blocking employment, then yes, I would say that would definitely contribute to persecution. If someone's livelihood and ability to feed themselves and their family, maybe not on their own, maybe on its own that might just be discrimination, but when you take it in the context of everything else happening, it's absolutely persecution. And then thank you for the clarification. Yes, in relation to both, but the work too, as he lacks any recourse.
Lauren,
Yes.
you're coming out. Lauren, I'm having
It's
a little trouble
good
hearing
answer.
you.
Thank you.
Lauren, I'm having a little trouble hearing you right now. I don't know if other people are having the same experience, but you're kind of coming in and out. But yes, that's an important clarification, a really good question. So this is making the point that economic deprivation, let's say if it was state sanctioned, is not in and of itself sufficient to establish persecution by itself, unless it threatens your very way of life. So let's say,
Yes, sorry, I just got,
but it is right that because this is cumulative, if you had a client who
can
told
you
you
hear
this,
me now?
oh yes, better, yes. But because it's cumulative, that's the right point. Lauren's saying, you know, this might not be itself economic deprivation, but if a client told you this, you would want to include it because, again, persecution is cumulative. So you'd want to put it all in, even if it doesn't stand by itself, the same thing as the discrimination. What about the threatening phone calls and texts? Would you include this in their asylum application as persecution?
I would think from what you just said, you would put all of it in.
Yeah. So even again, if you had a client who came in just by herself and said, I got some threatening phone calls and texts, and that was the full extent of their persecution, you would say, look, you probably had no past persecution under the standard. But where you have a case that looks like this, even though in and of itself won't stand on its own, threats and threatening phone calls and threats, you'd certainly want to put them in to be counted as persecution. And as we'll talk about later, it's really important to include facts like that for the purposes of tying your persecution to the protected ground. Okay, so it may be such that it also plays a kind of double role to help explain why the persecutor is targeting you, the applicant, but also what kind of persecution you might have lived through. Okay, Lauren, are you back? I can't tell, sorry. Okay, we'll just keep going until we have Lauren back on. Okay, so we've talked a little bit about persecution now, past persecution. We're going to talk a little bit about well-founded fear. So remember that your applicant for asylum has to establish either that they suffered past persecution in their home country on account of one of the protected grounds, or they have a well-founded fear of being harmed if returned to their country on account of one of those 5 protected grounds. Okay. One very important thing that we'll talk about is that once you have established past persecution, you have a presumption of a well-founded fear, okay? The burden lies with the applicant here to establish their own eligibility, to establish that they have a well-founded fear. Okay, the test of well-founded fear has both a subjective and an objective prong. Lauren, are you back? I can't tell.
Yes, sorry.
Okay, hi.
Can you hear me? My
Yeah,
internet
no worries.
cut.
We were talking about the subjective and objective prongs of well-founded fear.
Okay, perfect. So let me just get back to this. And I'm gonna leave my camera off in case that was the problem with my internet. So sorry you can't see me anymore, but hopefully
You just
this
have to
means.
see me.
So it's a two-founded, I'm sorry, I'm just jumping right back in. So if I'm repeating what Melissa's already said, then sorry about that. But so there's two prongs to a well-founded fear. So you both need to have a subjective fear of persecution and an objective fear. So subjective literally just means that the applicant is actually afraid, personally, of returning to their home country. They're afraid that they will be persecuted in their home country. And there's no need to prove that it's reasonable in order to meet the subjective prong. So I could be afraid to be in the United States because, let's say, I believe that aliens are about to attack and they're going to be looking for me specifically. And that is subjective fear. I am truly afraid that this is going to happen. Doesn't matter that there's no evidence to support me, or evidence verified by the government to support me. I am subjectively fearful, and that's all there is to it. The second prong is that there's objective fear, which means that a reasonable person in my situation would be fearful of what I fear. So that's where, in my example, that's where that kind of falls apart, is that a reasonable person in my shoes wouldn't be able to prove that there's a 10% probability that I'm going to be persecuted by aliens who are about to land in the United States. Now, it's important, you have to prove them both. And I raise that because it's often easy to assume you have the subjective fear, but you don't always have the subjective fear. Sometimes you have an applicant who objectively could be fearful, but actually isn't. Maybe they just have a really high risk tolerance. Maybe they don't believe the evidence out there. You need to establish it. But as long as your applicant affirmatively states that they are in fact afraid to go back, your subjective fear is covered, assuming they're credible. And then most of your effort is going to be in proving that there's an objective basis for that fear. And it's a pretty low burden. You don't have to prove that it's more likely than not that they'll be persecuted for asylum. You just have to prove a 10% chance that they might be persecuted in the future. So the way you tend to do that is by showing either past persecution, that they already have been, so it's likely they will be again, or by showing that there's conditions, that there's other examples of similarly situated people to your applicant who have been persecuted, and that makes it likely. So past persecution, as I mentioned, if someone has already experienced acts that rise to the level of persecution before they came to the United States or fled their home country, I should say, that creates a presumption that they have a well-founded fear of future persecution. So if it's already happened, it's presumed that it will happen again. But a presumption is rebuttable. So the government can then turn around and demonstrate that in fact in a particular case, that it's not actually likely that it'll happen again, notwithstanding the fact that it already did happen once. And the ways to rebut the presumption are and the government does this, right? Obviously, we don't do this as defense attorneys or people representing the affirmative applicant for asylum. But the government can establish that there's been a fundamental change in circumstances or that there's a reasonable internal relocation available within the home country. Fundamental change in circumstances. That means that things in the home country or things in your applicant's life are now different than they were at the time this person was persecuted, such that no one will want to persecute them again. A really common example of this is, let's say your applicant is a member of an opposition political party and that they're being persecuted by the government because of their political party membership. And then they come to the United States and they apply for asylum, but somewhere in this process, their party wins power in their home country. It's very unlikely that they're going to be persecuted by the party that they're a member of, being a member of that party. So that would be a fundamental change in circumstances that would rise to a presumption that could be rebutted. Reasonable internal relocation is a little bit more fuzzy and complicated. Basically what this means is that the persecution was geographically confined to a small portion of the country where they're from, or a large portion of the country where they're from. But there are other places in that country where they could go and live safely without being persecuted. So let's say there's a region of a country that is taken over by a terrorist group or a guerrilla group or a gang, and it's one state. So let's say we're in the United States and the state of New York is taken over by a guerrilla group. And I am persecuted by that guerrilla group because I oppose them. And so I flee and I go to Canada. But New York is the only place in the United States where this is an issue. All I have to do is cross the Hudson and go to New Jersey and I'm completely safe. If that's the case, I will not be eligible for asylum in Canada because I didn't actually have to leave the United States in order to get to safety. Now there are some, the sort of interesting thing about internal relocation is that persecution isn't the only factor in deciding whether it's reasonable for someone to internally relocate, right? So in the example, in my hypothetical that I'm proposing, that New York has been taken over by the guerrilla group. The rest of the United States is still run by the government of the United States and perfectly safe for me. But it's not actually perfectly safe for me because the rest of the United States, while technically controlled by the American government, is in the middle of a civil war with the guerrilla group or a totally different group. Maybe it's just, a third party so that there's not really a place in the United States where I could be safe from harm, even if that harm isn't persecution. Then it would not be considered reasonable for me to internally relocate. Now, where your persecutor is the actual government, it's presumed that the federal government, like the large government, national government, it's presumed that there's nowhere you can relocate internally because the government has reach into the entire country.
Okay, so we're going to talk a little bit about nexus now. So nexus is essentially the requirement that an applicant demonstrates that one of the 5 protected grounds was a central reason for their persecution. Okay, so as we've talked about already, you can't just show that somebody was persecuted or is scared to go home. It has to be on account of one or more of these protected grounds. This is a really important point that a persecutor can actually have mixed motives. They can both be persecuting you on account of a central reason, maybe your race or your religion, but also they can be persecuting you because they just don't like you, not a protected ground. Okay. Just a quick reminder that our 5 protected grounds that we're going to dive into a little bit more in detail: race, religion, nationality, and that includes ethnic or linguistic groups. So not just kind of nationality in terms of what passport you have, It also includes political opinion. This includes both opinions that you have, your actual one, or opinions that might be imputed to you, ones that people believe that you have, even if you don't necessarily have them. It also includes membership in a particular social group, which we could have another whole hour-and-a-half training on, but we'll touch on briefly today. Okay, so remember, you have to show persecution, that you were harmed. You have to show that it was that you have a well-founded fear. Either you were persecuted in the past, or that fear is subjectively and objectively reasonable. Is subjective and objectionably reasonable. And you also have to have a nexus to a protected ground. And so we're going to talk a little bit about this in a moment. Okay, so let's just take the first one, race. So race, religion, and nationality, we can take them all together. These are kind of more straightforward. So our protected grounds of race, religion, and nationality, there's no statutory or convention definition for race, but generally has a pretty broad interpretation. It can include race, color, descent, or national or ethnic origin. It can include persecution because you happen to belong to an ethnic minority in your country. It can include persecution because of the color of your skin. Nationality, as we've talked about, sometimes overlaps with issues of interpretations of race and ethnicity and religion. Okay, so these are all pretty straightforward. Again, three of the 5 protected grounds that we have. So I want to dig in a little bit more into political opinion. Okay, so as we just talked about, persecution on account of both actual and imputed political opinion is protected. Okay, so what does that mean? That means you are protected for an opinion that you actually have. For example, you believe in red and you're being persecuted by people who believe in blue. But it also protects the persecution, your persecution, by people who just believe that you believe in red, even if you yourself don't hold that belief. So if you walk around wearing red clothing and red hats, even if you yourself don't feel that you believe in red, persecution on account of people believing that you have that opinion is still covered by the convention and by domestic law. Political opinion also includes persecution on account of opinions that are broader than those that are traditionally associated with politics. So for the best example of this is feminism. Okay, so it doesn't necessarily mean that you have to have a political opinion that is associated with politics per se. You can have a political opinion that is defined by something otherwise. Okay, so a belief in feminism, a belief in the rights of your particular ethnic group, all of those would be considered political opinions, and persecution on account of those beliefs, actual or imputed, would also be covered by asylum law. The applicant also has to show the motivation to persecute arises out of the persecutor and the applicant's political beliefs. So the persecutor's motive to persecute arises from the applicant's belief, not the persecutor's political belief. In other words, just because you're being persecuted by a political party, let's say the Nazis, okay? So let's say you're being persecuted by a guerrilla organization that has strong beliefs. It doesn't mean that your persecution necessarily is political. You have to still show that the persecutor was persecuting you on account of your individual political opinion. Okay, and for this reason, a claim of political expression, a claim of persecution on account of political opinion, involves a complex and contextual factual inquiry into the nature of the asylum applicant's activities in relation to the political context in which the dispute took place. So this language actually comes from a pretty important case decided by the Second Circuit this past year, Hernandez-Chacon versus Barr. And in Hernandez-Chacon, the act of the applicant was considered to be a political act where it was considered in the broader socio-political context of where it was happening. Okay, so in that case, the Second Circuit found that the applicant's act of resisting the violent advances of a gang was political, because when they took into context the fact that gangs had controlled much of El Salvador, including the applicant's neighborhood, and the fact that law enforcement systems that normally protect women didn't have the ability to protect women, and that the applicant said that she resisted the gang's attempt to harm her because she had every right to resist, right? She was saying all this stuff about her own opinion about her right to resist their attacks. All of these taken into together and in the context of the socio-political environment gave rise to a finding by the Second Circuit that that was a political act, just resisting the advances of the gang. So even though she didn't call herself a certain political party, even if she didn't necessarily even say to them, I am a feminist and this is why I believe this, in the broader socio-political context, this act could be considered political. Okay, so it's actually a much more nuanced inquiry into what a political opinion is than it lends itself to believe. And as we'll talk about, in our cases involving domestic violence, we often assert both persecution on account of a protected social group of a PSG, but also political opinion, because in the broader socio-political context of a home, an act of resisting an abuser can be considered a political opinion. Given the time, I think we should skip this, but it will be in the training. So if you want to talk about ways in which this is political, we can certainly do that offline. Okay, so I want to turn now to membership in a particular social group. So the concept of what is a PSG is an extremely broad one, and it continues to evolve. This is also one of the most complex areas of asylum law. There's no definition in the INA or the 51 Convention for what a PSG is, but the original definition comes from Matter of Acosta, which Lauren talked about earlier today when she was talking about the definition of persecution. And in Matter of Acosta, the BIA established a rule for determining whether or not an asylum applicant has demonstrated membership in a PSG. And in that case, the BIA held that people who hold a common immutable characteristics other than their risk of being persecuted can constitute a PSG. And so relying on Matter of Acosta, a number of other PSGs kind of came out of that. So for example, families or clans, sexual orientation. In Matter of Kasinga, the BIA found that women of a particular tribe who opposed the practice of female genital mutilation could form a PSG. And in Matter of Fuentes, the BIA found that former members of the Salvadorian police could be a PSG. And so you can see here, it's an extremely broad array of groups of people that could form a PSG, but they all share one thing, which is a common immutable characteristic, essentially something that they can't change or shouldn't be expected to change. And then Matter of MEVG was introduced by the BIA in 2014. So after the Matter of Acosta test governed the test for PSG for decades, the BIA issued a number of precedential decisions in cases primarily involving gang-based asylum claims and evolved the definition and test of what a PSG is to expand it to a three-pronged test. And so in Matter of MEVG, which was decided in 2014, the BIA re-articulated, yes, this test from Acosta still stands. The first part of the test is that a PSG must have a common immutable characteristic. But then it clarified that there were two additional prongs to this test of whether or not a PSG actually exists. And the second prong was that the PSG has to be identified with particularity. And this was really in the essence of trying to identify a group that would be defined by characteristics that provide a clear benchmark in determining who falls within that group. So it can't be amorphous or overbroad. And a third test, part of the test, which requires that the particular social group be socially distinct within the society in question. And so this introduced the need to establish that not only did your group share a common immutable characteristic, not only do you have to articulate the definitions of that group in such a way that it's not amorphous or overbroad, but you now have to demonstrate from the perspective of society that the society that the individual lives in recognizes that this group itself is socially distinct. And so you're introducing the perspective of not just the applicant or the persecutor now, but society at large. And for this reason, we'll talk about what you put into your application. You need to put in quite a lot of material also demonstrating that the PSG that you're articulating is treated differently than other groups within the culture to be able to meet this third part of the MEVG PSG test. Okay. Just to touch briefly on domestic violence and survivors of domestic violence, because we see a lot of those claims. So in 2014, the Board of Immigration and Appeals issued a ruling in matter of ARCG establishing that domestic violence can be the basis for asylum. In that case, the PSG articulated was married women in Guatemala who are unable to leave their relationship. The BIA held, after many years of litigation, going back and forth in different cases, a social group that was defined by gender, nationality, and marital status does comport with the test that was articulated in MEVG and meets all of these different tests. The three-part test is required. And then in 2018, the Attorney General issued a presidential decision to himself, certified a decision to himself to then issue a precedential decision that was essentially overruling ARCG in part. And in a very broad decision that has quite a lot of dicta and appears to try to undercut gang-based and domestic violence claims, the Attorney General essentially held that ARCG was overturned, meaning that can no longer be cited by attorneys. And in that case, he purported to really narrow private actor-based asylum in domestic violence and gang-related cases. But it's really important to note, and we can talk about this more if you end up having a domestic violence-based claim, that matter of AB, while it made it much more difficult to establish a domestic violence claim, does not foreclose these cases. And that the important part is that that these cases have to be argued on a case-by-case basis. And as we've talked about before, in the context of unwilling or unable, matter of AB is the case in which the Attorney General purported to require that the standard of complete helplessness to protect. And so, you know, in these domestic violence cases, while they're not foreclosed, they've just gotten much more difficult.
I just want to mention really quickly, sorry, because I realized that we've talked about this a couple of times. I just want to clarify what we mean when we say the Attorney General certified a case to himself.
Oh, yes.
Not something that is
does not happen that often.
And it's not a thing in most areas of law, but basically because the immigration courts and the Board of Immigration Appeals fall under the purview of the Department of Justice. They're not part of the traditional court system. This is an administrative law branch. The Attorney General has ultimate authority over their decisions, and the Attorney General has the right to dig through the archives of presidential case decisions and decide that they were decided in error and change them. So many of these cases that the Attorney General certified to himself are decades old precedent that changed. So that's an interesting thing that I could go on a long tangent about that I won't.
Yes, we're gonna have a long discussion about this. But that is the posture of the case, and is and becomes binding on all immigration courts around the country. Yes, super important clarification. Thank you, Lauren. Yes, we could talk about that for a long time. So that's actually a really important point by Lauren, because that is also what the Attorney General did with matter of LEA, which established that or clarified that indeed members of a family can constitute a particular social group. So the perfect example of this was articulating that an individual in a family was being persecuted by a gang, let's say, because they were resisting the recruitment of a family member. And so in those cases, we would often have an LEA family claim. You're being persecuted by a gang on account of your membership in a family that has this person who's resisting. In 2019, the Attorney General certified to himself in the way that Lauren was just talking about, matter of LEA, in order to overrule the portion of matter of LEA discussing whether or not a family member was cognizable. And so dicta really makes very broad statements that family PSGs that essentially says, unless a family carries greater social import, so unless they're well known or they can be easily identified, any PSG articulating a family membership in that family isn't articulated as a PSG. And so maybe the way to think about it is this is family plus. So maybe family members of a person who people don't really know wouldn't rise to the level of family plus in matter of LEA, but family members of a well-known politician might still meet the test set forth in matter of LEA to be a particular social group. Again, like everything we're talking about, this is fact by fact, case by case, a fact-intensive inquiry of whether or not you have a PSG that exists. But as a general rule, families, unless you have kind of a family plus, will be difficult to meet this test set forth by the Attorney General in matter of LEA. Okay, so we're going to do one more case example. Please feel free to jump in. But Mrs. R is an ethnically Garifuna evangelical national of Honduras who was threatened and abused by her husband, a Catholic gang member. This is taken straight out of a case, as argued last year by one of our attorneys. She tells you that her husband and other members of his gang abused her because she refused to let her son, a 19-year-old boy, join the gang because she didn't believe in it. She also tells you that in one particular bad incident, her husband abused her because she tried to leave him, and because that night she told him that it was her right as a woman to live without him. She tried to report the abuse to the local police, but they wouldn't make wouldn't make a report because they were being bribed by the local gang, the same gang that her husband is a part of. Okay, so she is asserting her claim for asylum. So if you were the attorney for Mrs. R, what would you argue? What protected grounds can you see here? Remember our protected grounds, right? Race, religion, nationality, political opinion, particular social group. Name a protected ground that you can see here. There are so many.
And I just want to say, because I got booted from this, I no longer have access to see your typed questions. So please use your voice. Thank you. Does anyone think that there is a political opinion here?
Okay, let's narrow this down. Let's start with our persecutor as the husband, okay? So let's just looking at persecution by her husband. What protected grounds can you see here? Take a stab. Come on, we're on a training with all lawyers and law students. You guys can do this. Can we see religion? Maybe, right? Her husband is Catholic and she is evangelical. And so you might want to ask her, did he ever use any slurs? Did he ever refuse to let you go to church? Did he ever beat you because you wanted to go to church? What about ethnicity?
And I think it's fair to say that in most cases,
Yeah.
go ahead.
Thank you. Yes, tell us ethnicity.
Oh, sorry. I was gonna say yeah, potentially because she's Garifuna.
Mm-hmm. And great. And so you'd want to ask, is your husband Garifuna? Right? Or even if he was Garifuna, did he ever use any slurs indicating that maybe he he was doing this on account of your ethnicity or your perceived race? What about political opinion? This is where we might use our Hernandez Chacon argument, right? She told him, it's my right to live without you. She tried to resist him. And so you might make the argument that there is a political opinion here that in her resistance to his domination in the socio-political context of the home, this could have been interpreted as a political opinion. In this case, she really had it. It was an actual one. She said, it's my right to live without you. But even if she didn't say that, you might make the argument that it was imputed to her, particularly if his abuse worsened when she wouldn't take a subservient role, when she wouldn't do what he wanted her to do. Okay, this case example is actually really important for talking about how do we actually establish nexus, right? Pure speculation by your client saying, I think they did it because I'm Garifuna or because I'm evangelical or because he doesn't believe in what I believe in will only get you so far. You'd want to also draw attention to timing. Maybe it got worse when she asserted her belief in her evangelical beliefs. Maybe it got worse when she tried to go to church. Maybe it got worse when she tried to not be subservient in the home. So you'd want to maybe look at timing. You'd want to talk about language that the persecutor used when they were persecuting you or at other times. Did he use an ethnic, religious slur? Did he say, you're mine and I'm going to beat you until you're mine? You want to think about the broader socio-political context you're in, from the very high level to the very discrete level. What was happening when this happened? So that you can paint a picture for the adjudicator that shows the nexus. You're tying the persecution that happened to the protected ground. How can you do that? Okay, timing, slurs, background, broader political context. You have to bring them all in to paint a picture. Okay. All right, we're going to talk a little bit about bars to asylum. So even if you can establish all of these kind of requirements as to how, the fact that you yourself meet the definition of a refugee, there are some specific bars to asylum. And the one that we see the most often is when you're filing deadline. And so essentially, under the INA and the CFR, an application has to be filed within 1 year of the person's most recent entry to the United States. 1 year. Okay, there are some exceptions to this, including changed circumstances and extraordinary circumstances. Changed circumstances in this context can include changes in the conditions of your home country or to the applicant's circumstances that may influence their eligibility for asylum. So you, building on Lauren's example from earlier, maybe you come to the United States and you're fleeing and you were persecuted before on account of your political opinion, and there's an election, and instead of your party winning, more members of the party that you opposed come into power, or they get more power. That might be a good example of a changed condition, a changed circumstance that might make you more in danger of your return to your home country. Okay, it can also be an applicant circumstance, so your personal individual circumstance. There's a lot of case law around conversion to another religion that may be a religion that is persecuted in your home country. So that might give rise to some kind of change in your own personal circumstance that might explain the when you're filing deadline. Okay. Another really important exception that we see a lot is extraordinary circumstances. And extraordinary circumstances can include things like physical illness or mental or some physical disability. It can also include post-traumatic stress disorder, which we see often, where an individual is so traumatized by the persecution that they've endured in their home country, they could not possibly apply for asylum within the 1 year because they didn't have the ability to talk through the persecution that they suffered in their home country. Okay. Other extraordinary circumstances are being a minor, having lawful status. Okay.
And
Here's
the
another example.
filing deadline, sorry, is always told if you're a disability. So that's where being a minor comes in, but also that would potentially come in if you are mentally incapacitated.
Yes, and it's super important one because sometimes we see minors who come in and have, are only starting to grapple with their immigration status much later in their life, and may really have a real legitimate claim for asylum that we have to deal with the 1 year deadline for. This is another example. I don't think we have time for it, but really this one, if you want to go over the training later, really, it, again, is based on a real case that we have had and that we won, where we had to articulate quite a long period of time to explain the 1 year filing deadline, but we relied on both changed circumstances and extraordinary circumstances. So changed circumstances in the home country, but also extraordinary circumstances of PTSD to explain a lack of ability to file. Okay, other bars to asylum include being a terrorist, a persecutor, firm resettlement, which is where you have, depending on which regulation we're interpreting, whether you have passed through another country and have had the ability, been extended the ability to firmly resettle in another country, that may bar you from your eligibility for asylum. And some criminal issues, particularly serious crimes, can also bar you from asylum. Okay, whether or not something is a particularly serious crime is a case-by-case analysis, and that really considers the nature of the conviction, the circumstances and the underlying facts of the conviction, and the type of sentence imposed. Okay, Lauren, I'm going to let you turn to proposed changes since we only have 15 minutes left.
Yes, so I'm gonna very quickly just flag for you all that we just spent a lot of time talking to you about the standards that are applied and the elements you have to meet in order to be granted asylum. However, on June 15th of this year, the government proposed some sweeping amendments and additions and revisions to the Code of Federal Regulations that governs asylum. And it was open for notice and comment, which notice and comment period ended on July 15th. So literally just NILAG submitted a very extensive comment in opposition to these, but the proposed changes would fundamentally dismantle the asylum system as we know it and as we just taught you about. They're trying to create a definition of persecution that is extremely stringent with a very high bar. They're trying to create new requirements that you'd be required to establish to show that there was a nexus between persecution and your protected status. They're planning to put some really sweeping restrictions on what would make a cognizable PSG, including just barring you from having one if it's related to general country conditions or status as a woman or gangs generally. They're planning on putting in a new definition of political opinion that requires it to actually be related to a political party. They're shifting the burden on aside from, so internal relocation right now is a rebuttable, the government rebuts the presumption of a fear of future persecution based on past persecution by establishing internal relocation. They're shifting the burden to prove internal relocation isn't an option to the applicant instead of making it a way to rebut future persecution. They're planning to make the definition of firm resettlement rather than now, which is that you have actually been extended an offer to permanently settle in a safe country. It's going to be much more hypothetical. Maybe you could have been granted, maybe it's temporary but could become permanent. Basically, if you had a right to, or could have had a right to reside in any country other than the one you're fleeing for any period of time, maybe barred. Officials right now have pretty broad discretion in that they're supposed to grant anything where there's not an obvious negative discretionary factor. They're planning on limiting that exercise of discretion. And they're planning to impose new burdens on establishing the government's role in the persecution. And this is just a sampling of the changes. So all of this is to say that what we've said so far is the law as it exists today. And we very, very, very much hope that these proposed changes do not actually make it into the Code of Federal Regulations, or if they do, the court finds they're against international law, which they are. But keep your eye on the news.
That was that was an incredibly quick roundup. Very good and thorough. So I just wanted to briefly on withholding of removal and Convention Against Torture. While they are not asylum, they're often sought at the same time as asylum in our defensive practice. Withholding of removal is essentially the form of relief that most closely tracks our obligations under the Convention Against Withholding of removal is the form of relief that most closely tracks our duties of non-refoulement under the 1951 Convention. So this is non-discretionary. So as we were talking about, even if you can meet all of the pieces of asylum and show nexus, protected ground, you were persecuted, it's still discretionary. Withholding of removal is not. For that reason, it's the same definition of asylum, but it has a heightened burden of proof. The standard is more likely than not. Unlike asylum, which we'll talk about, asylum can lead to derivatives. So your family members coming to the United States or gaining status with the United States and citizenship. Withholding of removal doesn't result in citizenship. You can't petition for other family members. You can't travel. You do get an employment authorization document that has to be renewed annually. And it's an order of removal, essentially saying it's withholding your removal order for an indefinite period of time. So it tracks the ground of relief and the requirements very closely in terms of asylum law, but the relief is really different, okay? Importantly, the reason that we often seek withholding of removal instead of asylum is because there's no one-year bar to withholding of removal. The Convention Against Torture is also a non-discretionary alternative to asylum. We could have a whole nother training on this, but essentially there's two types of relief under CAT: withholding of removal, deferral of removal. Like withholding of removal, it's really limited relief. You have your order of removal that's withheld and you can get employment authorization, but like withholding, you can't travel, you can't seek status for other family members, and you can't get citizenship. This is really different than asylum and withholding, because instead of showing nexus, protected ground, persecution, you have to show that the applicant will be tortured, okay? There's no persecution requirement, there's no on account of requirement. Okay, so now we're gonna turn in our remaining 12 minutes to the nuts and bolts of filing an asylum application. All right.
And I will go back to my roots and speak fast like from Bruce. Because we have limited time and I want to make sure you all can ask questions if you have them. So there's 3 forums in which you can seek asylum. One of them is the affirmative context, which is where someone is here in the United States. They are not currently in contact with immigration. No one's trying to deport them, but they nevertheless choose to apply because they think they qualify and they are afraid to go home. The second setting is defensive. So that's when you're in immigration court. The government is trying to deport you and you assert it as a defense to removal. And the third is expedited proceedings, which basically, if you end up pursuing asylum in expedited proceedings, you're either trying to say, I shouldn't be in expedited proceedings because I qualify for asylum, or I have a fear, so you're trying to get into regular defensive proceedings, or alternatively, you're just trying to, you're in a proceeding in which the only thing you're allowed to seek is asylum, and it goes much faster and it's much more difficult, much more difficult to prove your case because you don't have the time and resources. But in all of these cases, step number 1 is to prepare an application for asylum. And the application for asylum is form I-589. So you fill out a literal government form answering a lot of questions, and then you provide supplementary evidence in support of it. And the difference is primarily where you file that. So if you're not in a defensive posture, if no one's trying to deport you yet, then you submit it to the Department of Homeland Security's U.S. Citizenship and Immigration Services, and your case is first heard by an asylum officer, who can either grant your case or refer you to removal proceedings, where you get a second apple. Or if you're in removal proceedings, then your adjudicator is the U.S. Department of Justice, Executive Office for Immigration Review. That's the immigration court. That's your only bite at the apple, essentially, beyond appeals, and you have an actual opponent. So whereas the affirmative application is adjudicated by an asylum officer in a non-adversarial setting, in other words, they're just trying to establish your eligibility. No one's trying to prove you're not eligible. In immigration court, there's the opposing counsel who's trying to actively convince the judge that you should not, in fact, be silent because you don't qualify. So it's definitely a more stressful position to be in, defensive over affirmative. But those are the primary differences. And my screen just went away. It gave me a poll to answer. Sorry guys, Melissa, what's the screen say?
Oh, this is the affirmative asylum process. So in that process, as Lauren was just talking about, your applicant is not in removal proceedings. And in that case, you're going to file your affirmative application for asylum, and then you're just going to attend your asylum interview after some period of time. Either your application is granted, or your application gets referred to immigration court and you find yourself in a defensive posture. So today we're only going to talk about affirmative asylum, and we're just going to talk about the nuts and bolts of what goes into one of those asylum packages.
Okay, my screen's back now. Thank you.
Okay.
So when you prepare an asylum application, your application package a detailed table of contents listing everything you're submitting and describing the documents. So we usually go for annotated tables of contents here, where we not only list titles of what's being submitted, but explain why they're relevant, because it makes it a lot easier for the adjudicator. The adjudicator in an affirmative context is the asylum officer, and generally speaking, they get their packages of applications the morning of your interview. So they have very limited time to review them before you actually show up to answer their questions with your applicant. And so as easy as you can make it on them, the better sense they'll have of what's happening before they start questioning your applicant, which means that the questions will be nice and hopefully less skeptical, because they've already seen what points you already are trying to make. Your index will include, what it'll include is case by case, but the things it will always include is the application for asylum, which is the form I-589 I mentioned. The form G28, assuming that you're preparing this for someone that you're then representing as their representative. That's your notice of appearance as an attorney, or law student under supervision of an attorney, which is allowed. Proof of identity. See, that's one of the sort of threshold things you have to prove in asylum, is that you are who you say you are, and come from where you say you come from, right? Because you have to prove that you're fleeing the country of your citizenship, so you have to prove you're actually a citizen of that country. You have to provide 2 passport-style photographs of the applicant for biometrics purposes. And you should always have a detailed affidavit explaining why the applicant is seeking asylum. The form, the I-589 form, does include places for you to go through that, but they're very short. It's like a little box, and there's never enough room on there to say what you need to say. And the ability, if you're just using those boxes, to structure the story in the way that's most compelling and clear. So you always want to have an affidavit, which is notarized, sworn to under penalty of perjury. You always want to submit an attorney brief in support of the claim. So in the affirmative context, that's often taking the form of a letter brief. Dear officer, here's why my applicant qualifies. That goes to the legal merits of the claim. So basically all the things that we discussed earlier, all the elements and why your client qualifies. And you always want to submit, so there's 2 categories of additional evidence that you might submit. One of them is corroborating evidence, which is evidence that the events your client is saying did happen. the facts your client is alleging are true facts. So that might include things like police reports, medical reports showing that they did in fact get injured and seek treatment, affidavits from witnesses saying, yeah, no, I saw that person get arrested and they came back home and they were bloody. You know, if you're seeking based on religion, you want some evidence that your client is in fact practicing their religion, things like that. And then the second category of supporting evidence is country conditions materials, which go to the well-founded fear question. They go to someone related to your client would in fact be fearful because the conditions in the country are such that people like your client are persecuted. And you always want to include the U.S. Department report as well as anything else you can find that would tend to establish that that it's at least 10% likelihood that your client's going to be persecuted.
So given that it's 3:26, that we have a few more slides, but really they're just going into, they're just elaborating on what Lauren has very well and very succinctly explained. So maybe what we'll do is let's use the last 5 minutes for questions. I know we've gone through a lot really quickly at the end. Learning to draft an affidavit for an asylum application is a skill in and of itself. You know, in terms of our basic asylum application, this should be your general checklist. If you find yourself saying, okay, I want to get started with this, you should, this is the kind of wide buckets of material you should be thinking about. So maybe let's use the last 5 minutes for questions. And if you have any questions afterwards, you can always feel free to reach out to me or Lauren about a specific case or any other questions that may have come up that we don't get to.
Yeah, absolutely. And I think our email addresses are hopefully available in here, but if not, mine is LREIFF as in Frank at nylag.org. In case you wanted to reach out privately about specific questions. And all that said, does anyone have any questions?
And I can now see our questions. So if you feel more comfortable typing in a question, please go ahead. No questions?
It's a lot of material, so as definitely feel free to reach out.
Okay, so given that it's 3:28, we can give you your 2 minutes back. Again, if you have any questions that you think of, or if you have a question about a specific case, please don't hesitate to reach out. We've kind of very much scratched the surface here, but if you have questions about the wrinkle of a specific case or you want to talk about PSJs or political opinion, we're always free to talk more. Okay? So thanks so much for attending. My understanding that this will be this is being recorded and so it'll be made available afterwards as well. Great.
Thank you.
Thanks, guys.
Thank you.